Major Maxwell jury problem. Juror number 50 apparently was going around the media giving interviews, hinting that he may have been less than truthful when he was answering those jury questionnaires. Pretty important part of the case. If the jury's bad, Ghislaine Maxwell maybe gets a new trial, and this juror just hired an attorney. You can see he has appearance of counsel here submitted by Todd Spodek Law Group out of New York, New York, and this is appearing for juror number 50. You can see here, not for anybody who's named. The name is the juror himself. And so we're going to peer into this. As soon as this became evident that this might be a problem, the government prosecutor submitted a motion. They alerted the court that this was going to be worth an inquiry from the court because that's how big of a problem it is. Let's take a look at the court docket. You can see a lot of activity here on January 5th, 2022. Letter motion. This goes into the court addressed to the judge, and it's from the prosecutors, from Maureen Comey, Allison Moe, Laura Pomerantz, Andrew Rohrbach. It's dated January 5th regarding an inquiry. An inquiry. We're going to see what that says. And boom, right after that gets filed, you're going to see several other motions come in, or letters. We've got Christian Everdell submits his, Jeff Paliuka, G is silent like lasagna, he submits his, and then the judge files this order. And it's a scheduling order, and we're also going to get appointed counsel. So the court is going to appoint CJA counsel. So it sounds like that juror actually got counsel appointed, didn't hire them. And so this person was probably a private attorney who has a contract with the federal courts. And so he just got appointed for the jury just to help counsel this juror to make sure this juror didn't do anything that would be adverse to his or her interests. If counsel for the juror wishes to be heard on the appropriateness of the inquiry, they can file. And so we'll take a look at all of that that's going on. So that's the court docket. But let's take a look at this letter. So the prosecutors, they now get wind that juror number 50 is out there doing some problematic things. What is he doing? They send this back into the court. January 5th, here's what it says. Judge Nathan, the government has become aware that a juror has given several interviews to press outlets regarding his jury service in this case. While the court instructed jurors that they were free to discuss their jury service with anyone of their choosing, some of the statements as related in the media merit attention by the court. You better look at this. In particular, the juror has described being a victim of abuse, the same kind that we're talking about in Maxwell's case. Assuming the accuracy of the reporting, the juror asserted that, quote, he flew through the prospective juror questionnaire, and he does not recall being asked whether he'd been a victim of that abuse. But he did say that he answered the questionnaire honestly. He says that he would have answered honestly if he had seen it. Doesn't remember if he saw it, but he would have answered honestly. And so that's kind of a big problem there for the jurors. If there was an actual juror with a prior history of sexual abuse, that's a problem. There's a footnote on that front page. It says the government is aware of at least 3 interviews where this was a problem. We've got interview 1 here, interview 2 here, and interview 3 here. One's from Reuters, one's from the Daily Mail, and one's from the Independent. So juror number 50 is just roaming around, hitting the media everywhere he goes. And we've got links to the stories. You can see those here. Ghislaine Maxwell juror breaks silence to the Independent. Says, quote, this verdict is for all the victims. Independent reported this. We have a quote. For those who testified, for those who came forward, and for those who haven't come forward, I'm glad that Maxwell has been held accountable, says a juror in the case. More from the story. Told the Independent that he voted to find Maxwell guilty of a majority of the charges against her because he believed the stories that were told by the V's. And he believed the pattern that they described. His name is Scotty Davis, wishes to be identified by his first and middle name. Told the Independent in his first media interview he believed all the victims in the trial that took place. He said it sounds like they're backed up by other evidence. David said he's proud to be a part of holding Maxwell accountable. Says, quote, the verdict is for all the victims, for those who testified, for those who came forward, and for those who haven't come forward. I'm glad that Maxwell has been accountable. And he says, quote, the verdict shows that you can be found guilty no matter your status. And so there's nothing really in there that sounds too bad, other than maybe he's got a political vendetta. He's kind of motivated. He has a perspective here. You can see that, but that's okay. He heard a lot of evidence. He's a juror. He's allowed to review the evidence, say what the facts are, and come to a conclusion. Let's see what else we have. The interview with the Daily Mail here. This one was published also January 5th, 2022. Exclusive. He also interviewed with them. Ghislaine was a predator, as guilty as Epstein, is the quote. Maxwell juror describes the moment that he, quote, locked eyes with Maxwell. Scotty Davis was one of the 12 men and women. Scotty says he went into the trial firmly believing that Maxwell was innocent until proven guilty. But after all I've learned, he says, she's just as guilty as Epstein. I don't want to call her a monster, but a predator isn't the right word either. During the trial, Scotty, who works in finance, was seated in the third row of the jury box in the back corner. From his vantage point, he said he had a vista of the entire court and a perfect view of Maxwell herself. Scotty said that Maxwell's manner in court was discussed during deliberations. He said, we did discuss. We thought she was a little standoffish. Not necessarily cold, more like she was paying attention. Scotty revealed that he was not the only juror to share a story of abuse. He said that it did not affect his ability to view Maxwell as innocent until proven guilty. So Scotty now is an abuse victim, and he's having conversations about that with other jurors. If that question was on the jury questionnaire and he didn't answer that affirmatively, there's a reason that question's asked, so that doesn't happen. Scotty is completely satisfied they reached the right verdict. He says justice has been done. He says that he believes she will spend the rest of her life in prison unless a deal is done. It satisfies me to know that we did our due diligence and that we brought justice for these victims, for these girls who are now women. Does he realize that this conversation might result in Ghislaine getting a new trial or walking free? Hate to be the bearer of bad news there. Final interview. Some Ghislaine Maxwell jurors initially doubted the accusers is the final story over from Reuters. During jury deliberations after the trial of British socialite, some jurors initially doubted the accounts. The juror, only identified by first and last name, said that some jurors had issues with Jane and Carolyn, two of the four women who testified that Maxwell set them up with Jeffrey Epstein. He said after some of the jurors questioned the accuracy of the two women's memories, he decided to share his own experience of being abused as a child. He said that when I was abused, I remembered the most important elements of what happened to me, but not every single detail. And he says that swayed some jurors. That swayed some jurors, he said. Minds were changed because he went in there and said, well, you heard from Carol. So a juror says, well, Carolyn, she didn't remember. How can you not remember something like that if this is such a monstrous thing that happened to you? I mean, isn't that going to be seared into your brain? She remembered some things, though, says somebody else. Yeah, but not the important stuff, says a third person. And Scotty raises his hand. He says, I was abused. Let me tell you how it works. Here's my experience. And the jurors say, well, I mean, you were abused. I guess when we can't argue with you and now we're feeling uncomfortable and you're sort of, did they ask you about that? Well, I filled out the same form you did. So, I'm here and, we're supposed to the judge said, use real world evidence and real world information. And what does it mean to you and all that? Okay. So he shares it and everybody listens. And Scotty says, when I shared that, they were able to sort of come around on, the memory aspect of the abuse. What was one of the main themes of the case from the defense? Memory. Money, memory, manipulation. Scotty's 35-year-old from Manhattan. He gave a phone call to Reuters where he wrecked the verdict. He added that coming to a unanimous verdict wasn't easy, to be honest. Well, probably not going to be easy the second time they have to do it either. There's a room of 12 people, and we all have to be on the same page and understand what's going on. Then we have to agree. So that's partly why it took so long. So those are the interviews that he gave, and the prosecutors catch wind of this, and they continue with their letter to the judge. And they say, Judge, based on that, Government believes that this court should conduct an inquiry. Yeah, because it sounds like might be a problem here. Referenced a case from the Second Circuit. Government proposes the court schedule a hearing in approximately 1 month, along with the appropriate schedule for a pre-hearing briefing regarding the law and the scope of the hearing. Okay, we got to figure out what to do about this. This is a new issue. In 1 month, why don't we schedule another hearing? We can talk about what to talk about, and we can talk about what law we should apply and all those things. Just a scheduling proceeding. 1 month. So Ghislaine Maxwell, of course, is going to have to be sitting there while this continues on. Well, she's thinking that this case should be dismissed. Her attorneys are going to latch onto this in 1 second. The government respectfully submits that any juror investigation could be conducted exclusively under the supervision of the court. If the court does decide to schedule a hearing, the government suggests the staff promptly contact the juror to notify him and inquire whether he wants a lawyer to be appointed. Government reached out to defense counsel last night regarding the juror statement, but defense counsel have not yet responded, and thus the government is not aware of the defense position on this issue. Signed off on by some prosecutor who didn't sign it for the government. And that's a spicy meatball. It's not good. Prosecutors are not happy about that because very likely that question was on the questionnaire and that person answered it in the negative. Otherwise, they would have been stricken so that didn't happen in a jury room. Now, we don't know, of course, what happened on the back end, but Maxwell's defense team screaming about it as they should. You can see here, Judge Nathan, they respond right away. This is Christian Everdell, says, "We write concerning an issue of pressing importance. It has come to the attention of the defense that one of the 12 jurors in this case, quote, the juror, has been giving oral and videotaped interviews to various members of the press concerning jury deliberations. These interviews have been publicly reported in several media outlets." We just looked at them. Among other things, the juror told reporters that he disclosed to other members of the jury during deliberations that he was a victim of the abuse. And he further described his memory of those events. According to the juror, his disclosure influenced the deliberations and convinced other members of the jury to convict Maxwell. And we can see here, paragraph redacted, carries on to the next page. Blank, blank, blank presents incontrovertible grounds for a new trial under Rule 33. Redacted sentence. Everdell continues, should the defense prevail on this motion, and we believe the law and facts are clearly on our side, it would render all other post-motion trial motions moot. Ms. Maxwell should not have to expend precious time and resources briefing other motions when this motion can and should be dispositive. We don't need to talk about anything else. Sentencing and what to do about all the other nonsense that we've got. The Rule 29 motion we talked about previously, it's irrelevant. This decides it. Accordingly, the defense requests the court schedule a briefing hearing for this motion alone and defer any other post-trial motions. That's from Christian Everdell. Over from Paliuka's office in Denver, Colorado, he files a letter. Judge Nathan, he says, I write in response to the government's letter of this morning, requesting a hearing to consider a juror's statement to various media sources. The government wants a hearing. I'm saying that hearing is premature. Based on the undisputed publicly available information, the court can and should order a new trial without any evidentiary hearing. We don't even need to talk about this, Judge. You've got links to 3 articles. They were in the prosecution's own disclosure motion to you, notifying you that this was going on in the first place. Look at the documents, look what this juror said and acknowledged in 2 different locations in 2 different articles, saying that what he communicated to his peers was dispositive. It changed the course. Paliuka continues. He says the Supreme Court has held that to be entitled to a new trial, a party must first demonstrate that a juror failed to answer honestly a material question on voir dire, and then further show that a correct response would have provided a valid basis for a challenge for cause. If juror 50, Scotty, answers in the affirmatively, yes, I've been abused, boom, you get a challenge for cause. He would have been excused automatically. This standard applies even if the juror's conduct was merely inadvertent and not intentional. Doesn't matter that the juror was just ignorant of the whole thing. He didn't know any better. He's trying to do justice. Nobody told him this. He just filled the form out. Poor guy. Poor Scotty. We read McDonough multi-part test is governing not only inadvertent disclosures, but also non-disclosures or misstatements that were deliberate. So it covers both, encompasses both. Pagliuca continues. Now we get a redacted sentence here. And then it says, all right, respectfully, it is not the proper function of this court to contact the juror and suggest that he retain a lawyer or secure the appointment of an attorney on his behalf. Pagliuca is saying you don't get to notify that guy because he's going to lawyer up and we're not going to get to the bottom of this. He says there is no indication this juror either needs a lawyer or is indigent or qualifies for a court-appointed counsel. He says any such action would undermine the search for truth and thus potentially compromise Maxwell's constitutional right to a trial by an impartial jury. So do you see another due process violation? If you lawyer this guy up, we're not going to figure out what he said. He's going to start invoking, and we're not going to be able to get to the bottom of what he told those jurors that might have improperly biased them. And that's another due process violation. Pagliuca continues. Maxwell intends to request a new trial under Rule 33 because the interest of justice so requires. Any submissions also going to include all known undisputed remarks of the juror, including the recorded statements, the relevant questionnaire, the other non-controverted facts. It's clear to Ms. Maxwell that based on this record alone, a new trial is required. Not requested, required. The law requires it, he says. Okay, but if this court disagrees, however, Maxwell requests that a hearing be scheduled sooner than 1 month from now. We're not going to wait on this thing. Ms. Maxwell also suggests that all deliberating jurors will need to be examined. We got to talk to all of them because they heard his conversation. They were in the same room as this guy. Not to impeach the verdict, but to evaluate the juror's conduct. Maxwell is drafting a Rule 33 motion to be filed on a schedule ordered by the court. Pagliuca is not happy about this. And you can see here there's a paragraph, a footnote. He says the government cites Langford in support of its request for a hearing. But the hearing in Langford concerned a different issue, whether there was an honest answer from a jury, whether that would have been a different challenge. So that doesn't apply. And so we can see that we've got two letters from two different Maxwell defense attorneys who are very, very aggressively upset with this, as they should be. How'd that happen? How'd this happen? All of this is proceduralized, so this doesn't happen. How'd that happen? We don't know. We couldn't see what was going on in court, so who knows? But Judge Allison Nathan now has a big can of worms that she's got to sort through. She's got the prosecution who's acknowledging that this is really screwed up, and she's got the defense who's citing case law saying, yeah, I mean, it's basically a foregone conclusion. The juror is acknowledging by his own admission that his statement wasn't theoretically material. It was actually material. It changed people's minds. They were waffling on this. Well, can't really believe her. He says, well, I was abused, and here's how my experience worked, so you should listen to me. And they did. And he acknowledges it. So they've got to get to the bottom of it. So Judge Nathan now has to figure out what to do about all this, and she does. She issues an order back. She says, the court is in receipt of the parties' letters. The court hereby sets the following briefing schedule for the defense to move for a new trial in light of the issues. New trial. Defense motion, January 19, 2022 is when they're going to have it filed by. Government responds by February 2nd. Defense replies by February 9th. The parties should also brief and address whether an inquiry of some kind is permitted. Can we dig into this? And if so, what does that look like? Also, the court reserves decision on whether an inquiry of any kind is warranted. The court grants the government's request to offer court-appointed counsel to the juror in issue. Subject to the juror's right to decline that counsel, the court will appoint on-duty CJA counsel to represent the juror. If counsel for the juror wishes to be heard, they can also be heard. The court will not adjourn post-trial briefing on other issues as requested by the defense. But we do set a following schedule. So we're going to be running two parallel things in motion. Defense motions on the other post-verdict motion. So that's going to be the rule motion, the judgment of acquittal. February 4th, response by the 18th, defense reply by the 4th. So ordered by Judge Allison Nathan. And so we've got two different parallel things happening. We've got the briefing on a motion for a new trial, and then we have the other post-verdict motions, which are going to be the judgment of acquittal. So we've got basically everything that they think the case should be dismissed up until the verdict, and then everything after the verdict that just happened as a result of juror number 50. And so he's got an attorney. Again, I don't know if he's hired or not. He could be CGA appointed, but juror number 50 is going to have an attorney. And so this case is going to continue to just be a big can of worms, and we are going to follow it along. And I hope you join us in that journey. Ghislaine Maxwell catches a major break, major gift on this one for her. And so we'll see where this continues to go. Hope you follow along. Hit subscribe. Give us a like on this video. We'll continue to follow this case. Leave a comment. Are you happy about this or not? What do you think about Scotty Davis? Scotty David. Ah, dang it. All right. I'll see you on the next one, my friends.